All right, let's get right into a huge Supreme Court of Canada decision from late 2023. This one tackled a massive question, one that gets right to the heart of how our country works. In a national crisis, can just one province kick off a lawsuit for literally every other government in Canada? Now, to really get this case, you have to understand where it came from. And this wasn't some dry, theoretical legal debate. No, this was born from the opioid crisis, a public health catastrophe that has tragically hit every single corner of this country, leaving a wake of devastation in so many communities and families. So, how in the world did this public health crisis turn into a constitutional showdown? Well, we're going to break it all down. First, we'll look at the lawsuit that started the whole thing, then the constitutional challenge it ran into. We'll explore the two competing arguments, the majority view and the dissent, and finally, we'll talk about the landmark ruling and the massive ripple effects it's going to have for years to come. Okay, first up, a crisis, a lawsuit. This whole story really kicks off with British Columbia deciding to try a really bold, totally new legal strategy. So picture this. It's 2018, and BC is getting hammered with healthcare costs from the opioid crisis. They decided to do something no province had ever even tried before. They launched this massive class action lawsuit against dozens of opioid manufacturers. But here's the kicker. BC wasn't just suing for itself. It basically said, we're the lead plaintiff for everyone. And by everyone, I mean the federal government and every single other province and territory. And to give this move some legal teeth, they passed a brand new law, the Opioid Damages and Healthcare Cost Recovery Act, or the ORA for short. So, part two, the constitutional challenge. Now, you can bet the pharmaceutical companies didn't just roll over. They fought back hard. And that set the stage for a really high-stakes debate about where a province's power begins and where it ends. The company's whole argument hinged on this legal term, ultra vires. It's Latin, and it literally means beyond the power. In legal terms, it's basically shouting, hey, you can't do that. You don't have the authority. They were arguing that BC's law was a massive constitutional overreach. And that brings us right to the core question the Supreme Court had to figure out. Did British Columbia go too far? Did it break the constitutional rules by passing a law that lets it sue on behalf of other governments that are its constitutional equals, without them even asking first? Now, to answer a question that big, the court has a method. It's a two-part test. First, they look for the pith and substance of the law. That's just a fancy way of asking, what is this law really about? What's its true purpose? And second, they check if that purpose steps over the province's territorial line. In other words, is it trying to control things that are happening outside its own borders? Okay, let's get into part three, the majority opinion. This is how most of the judges saw it, and it's why they ultimately sided with British Columbia. The majority's whole argument came down to how they framed this law. They said, look, this isn't some crazy power grab. They saw it as just a procedural mechanism. Think of it like a handy tool. It doesn't magically create new legal rights for other provinces. It just gives them a simple, efficient way to join a single big lawsuit if they want to. So how did they get there? Well, first, they said the law fits perfectly under BC's power to manage the administration of justice in its own courts. They saw it as a great example of cooperative federalism, governments teaming up to solve modern problems that don't care about borders. And since the lawsuit was filed in a BC court, it had a clear, meaningful connection to the province. But the most important part? They said no one's sovereignty was being violated because every single government had the right to just say no thanks and opt out. And this quote from Justice Karakatanis, who wrote the decision, just says it all. She basically said that in today's world, governments have to cooperate. The alternative is to let justice get stuck at provincial borders. And that doesn't help anyone when you're dealing with a national crisis. But it wasn't unanimous. And that brings us to part four, the dissent. Justice Cote had a very different take, arguing this was a dangerous overreach. Yeah, Justice Cote saw this whole thing completely differently. To her, this wasn't some simple procedural tool. She called it a substantive law, a power grab. She argued that by automatically roping other governments into a lawsuit, BC was messing with their fundamental property and civil rights. You know, like the right to decide for yourself who you're going to sue. Her reasoning is basically the mirror image of the majority's. She said the law is really about property and civil rights, a power the Constitution says is strictly limited to things inside your own province. So by including everyone else, BC was legislating outside its lane. This, she argued, stomps all over their litigation autonomy, their sovereign right to decide when and how they go to court. And that opt-out system, she didn't see it as a choice. She saw it as forcing other governments' hands, making them act just to protect their rights. This line from Justice Cote is so powerful. It really gets to the core of her argument. She's saying, look, even if all the other provinces agreed with this, and they did, it doesn't matter. You can't just agree to ignore the Constitution. Cooperation is great, but you can't use it to redraw the fundamental lines of Canadian federalism. So when you strip it all away, the entire case boiled down to this one huge disagreement. Was the BC law a helpful procedural tool that let provinces choose to cooperate? Or was it a substantive power grab that trampled on sovereignty by forcing them to act? Procedure versus substance, cooperation versus sovereignty. That was the whole ballgame. And that brings us to the grand finale, the ruling and its ripple effect. So how did the court land, and what does this all mean for Canada moving forward? Well, the final decision was pretty decisive. By a vote of 6-1, the Supreme Court of Canada sided with the majority view. The appeal from the drug companies was dismissed, and British Columbia's law was officially declared constitutional. And let me tell you, this is so much bigger than just a win for BC. This ruling is a genuine game changer. It basically writes a whole new playbook for how governments in Canada can work together. It's a huge green light from the top court, encouraging these kinds of creative, cooperative solutions for big, messy, cross-country problems. The ripple effects here are going to be massive. This decision gives a huge boost to the power of national class action lawsuits. It champions this idea of cooperative federalism, which will be critical for future crises, whether it's another public health emergency, climate change, you name it. It sets a really strong precedent for holding big corporations accountable when their actions cause harm across the whole country. But most of all, it sends a clear message. In Canada, justice shouldn't stop at the provincial border. So this case leaves us with a really important question to chew on, one that's going to shape the future of our country. In a world that is more connected than ever, where problems like the opioid crisis don't respect lines on a map, this ruling forces us to ask, where exactly should a province's power end, and where does national cooperation need to begin?